First of all, you need to come out on is how you gauge politics happen. When you have podcast or reception and make headlines, and a jumra na it be Akroma or Hasi. And it ma a hobraximu on your young court in Simu. Na a rema, a private legal practitioner be a better a news facts or trust them. A year unauthorized, security personnel are more a war a OSP office no. Ultimate intimidity a year lawyer Martin Pigunum. And say omu a transit or so a year because and yet a mandate say omu ebitimi a year sabia say omu a deliver omu commands. Now at this point in time, Wajamre or Bunchumu or diving into legal wisdom. Mr. Say mu ransom that any day about how saying 88 politics avenue. Young story.
Right, the altercation. What do you say about it?
Well, so you see, generally, as a person who will uphold the fundamental rights of persons against state institutions, I'm predisposed to saying that, well, the arrest and detention of Martin Kwibu based on the bail conditions granted him appeared to be onerous and was not excessive and not the kind of bail conditions that you will extract from an offense of misdemeanor. And so it was somehow heavy-handed, while recognizing the fact that all persons, when they appear before investigative bodies, have a duty, a civic responsibility to conduct themselves in such a way as not to bring themselves within the ambit of the law to necessitate their arrest.
Did he do that?
So, well, I'm just saying generally. Yeah. That's why I said generally.
Specifically.
Yes. I'm not going to go into. You see, I won't put myself. No. I won't put. I'm not counsel to
Martin Kwibu. He has said he's a lawyer for Martin Kwibu.
He's part of the team. That's why he's.
But he's a lawyer for Martin Kwibu.
And I'm not also part of the OSP. I'm a dispassionate observer.
Okay.
If I immediately transport myself into giving value judgments in a matter of this nature, then I'm allowing my prejudices to overtake, because I must be able, I must have the facts.
Thank you.
In such a way that I can make a reasoned conclusion and deduction from what happened. I'm just saying that generally, and we are all lawyers here, we know the overreach of the state. We know state power can be used to suppress dissent or to deal with people who are unnecessarily troublesome. State power can be used. So lawyers, our training teaches us that whenever there is an altercation, there's a problem between the state and an individual, you must rush to the aid of the individual because of the overbearing influence of the state. And I'm saying, using that principle, I'm tempted to believe that Martin Kwibu should not have been handled that way. As a private individual, what force has he? What power has he? He's mentioned soldiers standing at the gate. Martin Kwibu was not accompanied by policemen, let alone soldiers. So you can demonstrate the presence of the state, even at the OSP's office. So who will not in his mind think that, well, the power was so overbearing, and and if it is the breach of section 69(3), it's a misdemeanor.
That's correct.
And that section is repeated in all, laws.
Law enforcement
acts.
But it was not a breach.
What I'm saying, I'm not even. You're putting value judgments. You're not there yet.
He's lawyer for Martin Kwibu. So you must
not there yet.
He's here too.
Now, so when you look at that and stand with Martin Kwibu, you must also advise citizens, okay, that yes, when you are invited, and Martin says it clearly, when you are invited to assist in investigations. You must at all times be alive to your civic responsibility to assist in the investigation without unnecessarily creating a fuss.
Right. I return.
And let me tell you, when we lost 2016, you know the number of times I appeared for investigative agencies? Did you ever hear me?
No.
This one comes
no idea.
Yeah, I was Minister for Roads and Highways.
You bought the drones
No, I didn't buy the drones. I was Minister for Roads and Highways, a very senior cabinet minister. appeared several. They wanted information.
It comes to the territory.
And so they will invite you.
Well, as we understand, even in this regime,
Yes.
there are people who are appearing before investigative bodies,
knows.
but they are not saying anything. And,
They don't go
and I
with
can
media.
testify to that too, because I had just said in the interview with Martin that the week before I was at the OSP with a client.
And nothing happened.
Nobody,
Nothing happened.
Thank you. But thank you.
If you come
Thank you.
with drama.
But I want to thank you for that spirit where you go to the support of the individual, because the power of the state can be used against the individual so badly.
Yeah.
And that brings to my mind the Occupy Jilobi House, when the Democracy Hub demonstrators were being harassed. You drove from wherever you were, went to the police station to assist them. My firm were in court supporting some of those who were violated, and he generously agreed to testify to support the vulnerable people. Thank you very much for that.
Thank you.
Let me now go to Vicky Bright. Thank you very much for joining us from wherever you are, whether it's morning or not, like Manasseh Azuri. It's definitely not morning yet, so you people are doing a good sacrifice. And congratulations on your new position.
Thank you very much, Samson. And I just want to thank all those who voted for me wholeheartedly. Thank you.
Right. What's the office again?
It's Vice President for the Chartered Institute of Restructuring and Insolvency Practitioners of Ghana.
Congratulations. Congratulations. Okay, so what do you have to say about the first part of the discussion we have done so far?
Well, I think, like everyone else, I believe that I feel very strongly about this whole Martin Kpebu thing, just like all of us. The OSP, in my mind, had no business arresting and detaining him and asking him to justify the bill with landed property in his own name. I mean, I think that was excessive. And that act is naturally of great concern to all of us citizens due to its implications for our personal freedoms and our human rights, and in a wider context, democracy even. Because we cannot be intimidated or traumatized by our public institutions. And after all, if it is the case, or that he's not respecting rules, then why didn't they just ask him to leave and come back when he's ready to respect the rules? I mean, they could have just done that. But what happened seems to be using a sledgehammer to crack a nut. And as has been said just now, the power was so disproportionate. And so I think, we need to be careful. I also want to comment on investigative journalism. For me, Manasseh and the Fourth Estate and all our investigative journalists should be commended and celebrated and also protected, because they put themselves at risk every day for Mother Ghana. So I salute them, and I think all Ghanaians should.
In fact, they put themselves at risk perpetually.
Perpetually.
As lawyer for Manasseh, I can tell you it's not an easy thing to do. So that even just acting for him as lawyer, having accosted at the car park in the court's premises, and people like that, they will do a story today, but there will be people who will be looking for them forever. Because parents, wives, husbands, businesses, family businesses would have gone, So
Yes.
Thank you for that.
And these are powerful people, that they are trying to bring down.
Yeah.
Because the monies involved are not small monies. So I salute them, and we should all do what we can to support and protect them.
Right.
So I think that, we need to tread with caution in all these arguments. As at the same time, we need to tread with caution because of the implications for governance and democracy. And I'm talking about scrapping, the office of the special prosecutor. We must also distinguish between the office holder and the institution itself. Because emotions flare up when you hear about abuse or what we believe is abuse of power in the way Martin and others may have been treated. And then we say, bring the whole curtain down. And we must not throw the baby out with the bathwater. the OSP is one of the most important institutions for democracy and anti-corruption in Ghana.
Okay.
And so I think anything we do to either weaken or remove it risks undermining public confidence in governance and our accountability mechanism. However, if it is also the case, and we don't know this yet because it's been examined by the CJ as we speak, but if it is the case that their leadership is truly failing, in other words, they are mismanaging things, they are abusing power, they are being ineffective, then that also undermines public trust and confidence. So for me, the debate raises a deeper question. How can constitutional bodies be held accountable whilst at the same time preserving institutional independence and fostering public trust from all of us? You know, these ongoing petitions and any follow-up removal processes, we don't know how it's going to go. It may be that it stops and the CJ says, forget this, leave him to do his job. It may be that it could go on to the next few stages of that. But we need to be cautious in how this is done because it could also set a precedent for how other constitutional oversight bodies are treated in the future.
As we understand, Vicky, there are petitions against almost all the independent constitutional bodies, their heads. There are petitions to Shraj, there are petitions against NCC bosses. So are you beginning to see what the MPP had warned us in respect of the Chief Justice's situation, that this may become the new way to remove people who don't belong to us in a particular party, when they are in offices that the president does not have the power to just sack, when they win power?
I think we need to be cautious to also, categorize it as such. As for the Chief Justice's situation, we've it's been well traversed and cogitated and discussed, and I don't think we should mix the two. What I would say is that it is very, very important because of all the toing and froing and the hula baloo about Article 146, which we had with the Chief Justice. It's very important to ensure that everything is seen to be above board so that there are no accusations of orchestrated orchestrated removals by political elements.
Right.
So that's what I would say about that.
Okay.
Yes. Yes.
You made this comment. I thought you should expand it further. When they required landed property in the accused or the suspect's name, so to speak, we have seen that in the last, few days, people who are going to Ioko, wherever, this has been used against them. Is it a wrong thing?
Well, it's not a wrong thing per se, as a general proposition, but I'm just looking at what Martin Pebu was saying.
Why is it not wrong? Because if the poor person who doesn't have a house, doesn't have land, when they get arrested, then how do they get bail?
I think you have to look at the kind of people that Ioko is dealing with and the monies involved and all of that. I don't have a problem with certain kinds of people being asked to do that. But of course, you cannot ask, not everyone owns a house. Not everyone has landed property. So if you make that as the sole bail condition, then you are going to seriously undermine people's freedoms. So that will not work. But if you are alleging someone to have done the things that they are alleging people to have done, and you're asking them to bring properties in their name, then I think it is fine. At the same time, it is important that they are also given an opportunity in the alternative to bring other properties. If someone else is willing to stand as surety and justify it with their own property.
In this Kenoforiata situation where we say we have allowed him to run away, do you get the impression that we may be doing something wrong? We seem to have pronounced him guilty even before the matter is gone into.
The difficulty with this whole thing is that Ken is not making himself available. He's not coming back. So other people traveled and they came back. You know, Dictiowari and others, they traveled and they came back to the country. So as long as you're out of the country and now they've been formally charged, if you don't show up to defend yourself, then, you know, people would think that you have something to hide. So for me, if you're accused and you know you're innocent, then you show up and you stand tall and you defend yourself. That's what you should do. But if you don't show up, then it suggests that, you know, there's something wrong. And of course, there was a time when he was having medical treatment. I can't hear
This
you.
to carry on the discussion as if he's already guilty. That's not a basis to, the fact that he's not available, it's not a good basis for that kind of presumption, including by lawyers like yourself, that he's guilty already. It's not right, is it?
Presuming Ken is guilty. Everybody is innocent until proven guilty. So I'm not making that presumption. What I am saying is that if you're accused, and all of us, you know, if anyone is accused of anything and they are refusing, or they are seen or perceived to be refusing to come and defend themselves, then people ask questions. I mean, people are just human, aren't they? But of course, for us lawyers, we work with facts. We work with facts. So for me, everyone is innocent until proven guilty.
All right.
Ken should come back and prove his innocence.
All right. Thank you very much, Vicky Bright. I will need to go on a break now. But before I do that, I had already hinted the two of you have been actually arguing involved in a heated debate as to you say there's no basis, no grounds at all. The OSP doesn't have power to do any such arrest.
The OSP had no jurisdiction to arrest Mr. Kpebu. Let me explain. The OSP's Act makes it a specialized institution. It's in the law, specific to arrest, to investigate and deal with corruption-related issues. You know, public persons and politically exposed persons under the authority of the AG, and has been given some police powers to exercise pursuant to that. If you read their Article 63, the obstruction part and that kind of thing, it is if in the
Section 69.3.
in the course of their duty, if you obstruct them, then they can cause the arrest as a terror. If somebody walks out of your office to go and give an interview and walks back in and is accosted and is involved in a verbal altercation with a police person, that does not constitute an obstruction of that investigation, because he is not even an investigation. You invited him to come and help you to do your investigation. So where is the obstruction? Look, the questions are simple. Who did Martin obstruct? All right? Was Martin under investigation under the law of the OSP? Who arrested Martin? Was it the OSP or the soldier or the police? These are the questions that must be answered. And then let us appreciate this. Martin has every right as a citizen to say whatever, that's the law, he wants to say about a public official. If the public official feels aggrieved, he should sue him in defamation. Martin does not have to be right to be in his rights. But then he can make those petitions to the president. The president can look at it and throw it away. He has committed no crime.
So your point is that in this circumstance,
there was no obstruction of the OSP.
69.3 was not
absolutely
occasion.
Not. If you give me,
but not that the OSP doesn't have this power.
No,
that's what you're saying.
The OSP doesn't have this plenary power. A plenary power means a power like a police power to arrest anybody for any kind of obstruction. The OSP may only arrest somebody who obstructs their work directly. Martin was not even part of that.
Okay.
And did not even obstruct their work.
Right.
That's the point.
Thank you.
I think that he's gotten everything completely wrong.
Read 69.
No, wait. When you were talking about
you
like him. Okay. Section powers of the office.
You are telling somebody he
yes, because he reminded me when I wanted to.
Okay, now you to stop.
Powers of the office. Office of the Special Prosecutor. Section 28. Officers to exercise police powers. The Special Prosecutor and authorized officers shall exercise the powers of a police officer specified in the Criminal and Other Offences Procedure Act 1960 Act 30 or any other enactment. So if we are talking about plenary powers, is there? That's one. No, that's just one provision.
So the powers given to the police under the Act 30 for them to arrest on suspicion and so on and so forth. This is what you are reading, that the law says they have it.
They have it.
Okay.
They have it. Number, the section offenses relating to search, seizure, and obstruction of authorized officer. That's 69. Okay. The 69(3) says that a person who obstructs an authorized officer from performing a function under this act commits an offense and is liable to summary conviction in the case of an individual for so and so and so. Now, so they have those powers. And we gave them those powers. And he was there when the law was being crafted. We gave them those powers because we were creating the office of the special. You know, one day you asked me what is different, and I said, well, we are talking about a special prosecutor.
We ain't some of the team cost or channel, so I'm not so Jim or Senate or body in the Domian. The Basamba room, not Yaxumi, a gauge for Texas.